Right, how to do this one without getting cancelled? Well, I can think of two ways. First of all, please like the video, subscribe to the channel, leave a comment below, hit the notification bell, share the video with somebody because that will tell YouTube you like the video. Now, I know I haven't really started yet, but that will probably help. The second reason, caveat, this video is not intended to upset anybody. It is just an explanation of the law and a problem with the law as I see it. So this is an overview as to what's going on. Right, so where do I start? Right, well, I start with a tweet that I read, or a post if you insist, that I read earlier today from regarding the National Governance Association, which is an organization, like a membership organization, that provides guidance and assistance to schools across the country. And the latest article from The Telegraph says that they've issued guidance that all schools across the UK must allow trans people to use the bathroom of their choice, and the shower rooms, I think it said, of their choice. Now, there's a problem with this because there's bits of legislation that sort of contradict each other in a sense, in that we've got the Gender Recognition Act, which provides that somebody who obtains a full gender recognition certificate obtains, for all intents and purposes, the sex of their required gender. And so those who are transitioning to be a man eventually have the sex of a man and are treated as such, and vice versa. Now, there are certain sections of that Act which do provide that there are certain exceptions and the way people can be treated differently. And one of them, for example, is sport. And under Section 19, it says a body responsible for regulating the participation of persons as competitors in an event or events involving gender-affected sports may, and I'm reading this off my phone, may, if subsection 2 is satisfied, prohibit or restrict the participation of as competitors in the event or events of persons whose gender has become the acquired gender under this Act, and those two being fair competition or the safety of other competitors. In English, that means a sports organisation can say, well, even though you've got a GRC to become a woman or to become a man, we can restrict you from participating in that category because of fairness or safety of the other competitors. So most sporting organisations already, well, I say most, some sporting organisations already rely on this to ensure fairness in competition, safety, etc. Although I read again just today, there's some debate over this issue, but that's not specifically the purpose of this video. This video is about the use of bathrooms and shower rooms and so on in schools. I think that was relating specifically to teachers, but dare I say that might also apply to students as well. Now, the problem that we have, now I say problem because it's an ambiguity and a confusion. I don't mean to be disrespectful to anybody here, but the problem that we have is the understanding and the interpretation of these laws and then how they are implemented. The result is that most organizations will probably implement them in accordance with the least possible risk to them from a legal standpoint of a claim by an individual against the organization. I'm going to spell that out absolutely bluntly. That is what I think is an organization's primary concern. They are risking or trying to avoid the risk of being sued for being non-compliant with any of these laws. But what does the law say? Well, the law says that under the Equality Act 2010, we have various protected characteristics, race, religion, sexual orientation, but it also includes specifically sex and gender reassignment. And so if I were to read to you precisely what gender reassignment says, the protected characteristic of gender reassignment under Section 7 is where a person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of the process for the purposes of reassigning the person's sex by changing physiological or other attributes of sex. And of course, then to go on to get a full gender recognition certificate under the Gender Recognition Act of 2004, then the person then acquires that sex for the purposes of the law, going forward but not going backwards. However, it doesn't end there, because just as there was with sport, there are other certain areas of law in the Equality Act that provide that there can be lawful discrimination if it is to achieve a legitimate aim and it's a proportional means of doing so. For example, under paragraph 28 of Part 7 of Schedule 3 of the Equality Act 2010, this applies to gender reassignment. And I'm navigating and turning to landscape on my phone here. A person does not, and a person, by the way, can mean a man, a woman, or an organization, because organizations have got a separate legal entity. So a person can mean an organization under any piece of law. A person does not contravene Section 29. Section 29 is the discrimination on the protected characteristic of gender reassignment. So a person does not contravene Section 29 so far as relating to gender reassignment discrimination only because of anything done in relation to a matter within subparagraph 2 if the conduct in question is a proportionate means of achieving a legitimate aim, which is what I mentioned before. And those matters are the provision of separate services for persons of each sex, the provision of separate services differently for persons of each sex, and the provision of a service only to a person of one sex. And so you can see there that it is not discriminatory to change the way that those services are provided based on the protected characteristic of gender reassignment under Section 29. But the problem here is the ambiguity, and this is a long-standing debate. There have been lots of letters going back and forth, different interpretations, and therefore the net result is organizations applying it in one specific way or another. The net result and the net problem in inverted commas that I see is how organizations will treat all of this law and the usage of bathrooms and shower spaces and so on, and the guidance provided by this National Governance Association, which, by the way, it does not have any legal authority over schools. It's just a membership organization providing advice. The advice that they are providing ostensibly on the face of it is a precautionary approach across the board to try to have these schools avoid being sued for getting this wrong. But in doing so, I believe that it would mean that they are advising schools to just allow everybody to use these facilities because of how they identify. I disclose I haven't read the guidance, I've just read that it exists through the Telegraph article, but that's what it seems to me. But this advice, reported by the Telegraph and seen by the Telegraph, says that trans teachers must be allowed to use the same showers and lavatories as female colleagues, according to, and this is what the schools have been told. The training provided by the National Governance Association tells governors that staff should be given access to the bathroom available to other members of their newly acquired gender. It says requiring transgender people to use a disabled toilet instead of making reasonable adjustments is not lawful or good practice. Now, again, given the disparity between the two pieces of legislation and gender as against sex, because unless you have, just to clarify, unless you have a full gender recognition certificate, then it is gender reassignment and not a newly acquired sex per the definition of the word in the Act, although there is still an ambiguity between them, and I'll come back to that in just a moment. The Telegraph does say here that this advice says employees who've undergone gender reassignment who are transgender must be supported to use all toilets and shower facilities which are available to other members of their newly acquired gender. A chair of governors speaking to the Telegraph said that I've decided to take the NGA Equality and Diversity training today to keep myself up to date. I am shocked at this content, the chair of governors said. That's part of the slide deck. Mayor Forstater, who I've mentioned on this channel before, the CEO of Sex Matters, a human rights charity, said the training was grossly irresponsible and deeply disturbing. She said, nowhere in the Equality Act does it say that men who identify as women have the right to access female toilets, so this is a shocking misrepresentation by the NGA. And legally, from a legal standpoint, I would agree, because the Equality Act, as I mentioned in paragraph 28 of Part 7 of Schedule 3 to the Equality Act 2010, provides that they can make these changes and it would not be discrimination on the basis of gender reassignment under the Act in that way. The quote from Mayor Forstater goes on, employers are required by law to provide single-sex toilets unless they are fully enclosed unisex rooms. It is grossly irresponsible for the NGA to tell school governors and trustees otherwise. She says the Equality Act protects transgender people so that they can't be harassed or discriminated against, such as being denied employment or housing. It doesn't give them an all-access pass to the opposite sex facilities. It's deeply disturbing that school governors are being misinformed by the NGA in a way that breaches the rights of teachers and other staff to basic privacy and dignity. And so this video here from me is not to upset or disrespect anybody. It is really to raise awareness of these issues and really to say that I agree with that legal standpoint and that simply self-identifying does not allow a person into a different space than they would otherwise be with their biological sex. This is obviously a very hotly debated topic, gender versus sex and so on, and the law is trying to grapple with it. So the law, as I see it, is currently inadequate in that it is not entirely 100% crystal clear, which in my view and in my experience leads organisations to take a very risk-averse approach, and it would seem this National Governance Association to take a risk-averse approach in providing guidance to schools and organisations to do exactly that and just give in and take this risk-averse approach. Or dare I say it, just the give-in approach. I'm not really sure which it is, whether it's just to give in or whether it's to be risk-averse. But one way or another, I think that, with respect, I think that guidance is misguided. And I would take this opportunity to remind schools and governors, especially the chairs of governing boards of schools, that this NGA guidance is just that. It's just guidance. And if you do watch my channel and you want to write in and give me your views, I'd be happy to share some of those views as well. Because, as I say, it is just guidance, and my view is that that is misguided. I would have to say that I share the view of Mayor Forsetter on this one, particularly with the very prominent case that she's been involved with, and that I would say that this guidance in the training is irresponsible because it is not entirely accurate, and it is, in my view, going to lead organisations into quite a bit of difficulty. So leave me your respectful thoughts and comments in the box below. Do subscribe and share and like and all that sort of stuff so that actually more people see this video, because, as I say, these kind of videos don't typically get very many views, but I had to do this to sort of raise awareness. So thank you for watching, and I'll see you next time.